MST appeal, Lordship. What happened in this case, Lordship? Already appeal is admitted subject to the payment of the 50%, Lordship. But appellant till date neither pay nor listed the matter. That is why, Lordship, come upon next week, Lordship.
Next week, almost full, but I 28. 28.
Deeply obliged.
Yeah, being Lordship. Also, with the consent of other side, my lord, I will mention item number 14, my lord. 1/4.
1/4.
Lordship. Second, after
You are for the appellant or respondent?
I am for the appellant. But second consent of the respondent.
Respondent second. Consent of the appellant. After 3 weeks will do?
Okay.
Yes, after.
May I please, Lordship, beg to mention two orders matter for listing in the next week. Any date, my lord? 2nd February.
2nd of February.
May I please? I beg to mention item number 11, Lordship. Counsel Mr. A. Bhattacharya, due to some medical reason, he is unable to present today, Lordship. Can we kindly pass over and some
Item number 11.
11?
When I was there, I think
IA is for delay, but I'm not empaneled in insurance on his behalf.
you are for the appellant, na?
Yes, yes.
Okay. Due to medical emergency. After 2 weeks will do?
Yes, sir. Obliged.
2 weeks.
May please, your lordship. I beg to mention for listing, MSc appeal was prepared by the insurance company. Notice was issued just file a wakalatnama matter. So matter is pending 2020, my lord. It will come on next week, matter anything.
Next week, not possible. 2nd February.
Not my lord. Then 3 or 4 February, my lord. Okay.
3 or 4.
Yes, yes.
3 can be.
4.
Then 4.
Obliged.
May please lordships. 1 minute MSc appeal matter. My lord, that was placed before the last Loko Adalat, my lord, National Loko Adalat. But the claimant, the respondent in the appeal, my lord, could not appear. That's why, my lord, matter may be taken up on 29 if possible for listing, my lord. 29, my lord. That was already, my lord, matter has been settled, my lord.
Already over. List is
Yeah,
over.
my lord, then, my lord,
Second but third proper.
kindly date me so that I may be,
How can I fix the date? I'll list your matter will be going to list only.
yes, yes.
Yes, 4th of February. 4th.
Obliged, my lord.
May I please? I'm praying for listing of an order for order matter, Lordship. Any as per Lordship's convenience, because this matter is not listed for a long time. Any day, first week of February or
5th of February.
5th.
May I please your lordship? Lordship, I beg to mention item number 18, lordship. Item number 18. With consent from the other side, lordship, there may be fixed another day.
You're for the appellant or the respondent?
I am for the respondent, lordship.
Okay. Consent of- Contact fixed date.
Lordship.
19th
of February.
May I please, Lordship?
Obliged.
I beg to mention for a pending matter of matrimonial appeal, my lord. Any date may be fixed on first week of February, my lord.
6th of February.
Obliged.
May I please? But I beg to mention for listing of interlocutory application in orders column, my lord. My lord, in this matter, execution has started, my lord. So, my lord, kindly list on 28, my lord.
28.
Yes, my lord.
Please, zero.
Okay. Obliged.
Lordship, I beg to mention item number 6 of today's daily list, your lordship. It's an AB application, but CD has not been received. Interim was passed on 16/12, your lordship.
Are you on interim?
Yes, your lordship.
CD we have not received. Sure. When it can be listed? First week of February, 9th of February. Interim be continued.
Much a pleasure.
May it please your lordship, I beg to mention 3 RFA to be listed in the orders column. Your lordship, in one of them, the additional affidavit has been filed, it has been 4 weeks since. And in another, the matter was adjourned back in 2024. It has not been listed yet. So your lordship, any day of the next week.
9th of February.
Okay.
May please your lordship, I beg to mention one RSA for listing in orders column, lordship.
RSA.
Yes, lordship. RA has been filed for early hearing, lordship. On
9th of February.
the lordship, can it be on next week, lordship?
No, not at all.
Please, Your Lordship, I paid for listed MSc appeal in orders claim for the claimant, Your Lordship, I respondent, insurance company has filed.
6th of February.
May I please, Your Lordship? Lordship, I beg to mention one MSc appeal for listing, Lordship. I'm from the claimant appellant, Lordship.
6th of February.
May I please your lordship, 483 application lordship. Lordship, in this case, RCT was given lordship, and now the statement of the victim also is recorded lordship. On 2/1/2026, I have annexed it in page lordship 45 lordship. Lordship, from the evidence lordship, it is said clear that the victim girl had a love relation where and mutually see us in our will they had sexual relationship with the accused lordship. And according to the will, the victim herself accepted the fact that she had on her own will consented to the relation.
Our case, Lordship, note reading, please. Page 51, Lordship, this is the cross part. Lordship will kindly peruse paragraphs 27, 28, and 29.
Yes, they are maintaining.
We go. Pishma related to PP. It is submitted by MS Google that the present is not committed to such validity. However, it is the fact that the accused petitioner and the victim had a relationship, and the accused assured to marry her, getting a job, and in that context, they were having sexual relationship with her consent, and they had, and whatever physical relationship was between the parties were purely consensual. Further, the accused petitioner is in custody. Since when? He is in custody? 14/6.
This lordship,
14/6.
question just to mother you lord.
And 4 witnesses have already been examined by the prosecution. Considering all these aspects of the case, the petitioner may be allowed. He being a permanent resident of his address locality will appear on each and every date to be fixed and will cooperate in the investigation and will contest the case. Where Mr. Sharma, the learned petitioner, will be submitted that from the evidence of the victim herself, seen that there was a love relationship between them. And the relationship was consensual. But there are other matters in the evidence of the PW, and accordingly it is in granting bail to the then submission being filed and consequences. I have also read the evidences filed along with the petition, especially the evidence of the victim, which has been annexed, along with considering the evidence of the victim as well as the other evidence. I find that further custodial detention may not be necessary for the present case. In view of this, I find it justified to allow the application to go on bail. In which court it is pending?
Yes.
Session judge. With the satisfaction of this
Session
judge.
Lordship,
Session judge nothing. Okay, you are granted bail.
21 of the
Bail grant.
Me, please, your lordship. Lordship, we were supposed to file an affidavit in this matter, lordship. Lordship, we have not received the sworn affidavit till now. Otherwise, our affidavit is ready, lordship. After receiving the sworn affidavit, we'll file it, lordship.
What affidavit?
We have sent it to the department for swearing the affidavit, lordship. But we have not received that sworn
But on the
affidavit,
last
lordship.
occasion was probably
The
Mr.
last
Mahmood
time
also raised
also,
objection, but we have allowed
Yes.
it that you need some time, so accordingly it was allowed.
Lordship. Lordship, otherwise it is ready. We can serve it to the other side, but we have not received this sworn affidavit, lordship.
So who is going to sworn the affidavit?
Lordship, we have sent it to Inspector of Schools Borpeta, Lordship. After receiving the sworn affidavit, we'll file it, Lordship. We are trying to contact the person, Lordship. They have not received the call, Lordship, since yesterday. And we have sent the affidavit to them, Lordship, 1 week back. And it was Bihu, Lordship. So maybe because of that, there is some difficulty, Lordship. Otherwise, it is ready, Lordship, along with annexures. But before serving them, Lordship, that's the
Sorry,
difficulty,
it's
Lordship.
my lord,
Yes, Lordship.
actually, this is, I think it is a delaying tactics because the school is situated at village Bhukuapeta, but they do not write the name of Bhukuapeta. Earlier,
Name of Bukapata mane?
my lord,
Name did not write the name of Bukapata means what?
Bhukuapeta means the village, the school is situated at village Bhukuapeta. Kindly see page 37,
Whatever, they have not written the name.
written the name. But earlier it was used as Bhukuapeta. In all mark sheets, admit cards, everything is there. But some person, due to some village conflict, they filed a complaint before the IS that this Bhukuapeta name should be omitted. Then IS rejected their petition. That earlier communication, full communication shall prevail. But only after 4 months, again the IS passed the same order that Bhukuapeta shall not be there. It will be the B.R. Milan School, Post Office Ravli. Where it is situated, that is not mentioned. Earlier it was mentioned. All documents bear the name Bhukuapeta. So, this is, my lord, something unusual.
So
We-
when your probability of getting a sworn affidavit?
Lordship, within a week, Lordship. Because
Within
today,
a week means
Next
from
week,
onwards 5 days.
Lordship, next week, Lordship. Because there will be holidays, government holidays as well, Lordship. Lordship, next week, Lordship, 30th of January, Lordship, next Friday.
27, it will open. 27.
Ako jodi ahi na pa ako problem to bond.
Oh, you will
That's the
call about-
difficulty, Lordship.
Why the
Otherwise, Lordship, from our side is ready. Lordship, I can service to the other side as well. But it won't be proper, Lordship, without getting the sworn affidavit serving the other side.
Okay.
No,
Lordship.
there are so many officers. Assistant IS can also. This is not a ground because earlier 2 times they have taken that ground. So, my lord,
Lordship, we are trying to expedite the process, Lordship. We are not trying to delay the process, Lordship.
it has become a quarrel in the village that why is our village's name shall not, what offense we have committed. Though the school is situated in our village, but name is not written. So, my lord, if your lordship grants any time, that should be last time, and interim may be considered on that day.
For Mr. Member, the petition transferred Ms. Arwood Leland, standing counsel. Secondary education. it is submitted by the school that they already prepared the affidavit, but as there was a holiday, few holidays, we could not get the sworn affidavit, which is to be filed today. Otherwise, the affidavit is ready and it is can be filed even today. If it gets this one, Mr. Mahmood is objecting and submitted that since past 2 days they're taking the respondents are taking time, and matter is though the matter is very considering the submission and let the matter be decided. You are saying 38.
Lordship, there will be some time, Lordship, instead of
Let the matter be decided. 30 with a direction to the respondent side file the without any further the in default the no, no. So we are listing it on trees.
Lordship.
And on that, the interim may be considered, but that may kindly
Generally,
go.
my side, by this court, I don't pass such kind of order. If the interim can be considered, it will be considered. Because that observation sometimes create problem to the other courts otherwise. Anyway, what you are also paying for it for an interim. Okay, then interim may be considered. No, prayer for interim will be heard.
All right.
Seven Lordship, 302 case Lordship. Here I have done to the scan copy Lordship. It is all not legible Lordship. I have flag mark Lordship the PWs that are annexed PW scan copy.
লিজিবল নহলে কি করা যাবে? মানুষ তো
I have flag mark Lordship the evidence.
Oh, what can do? একটুই গম নাপায় এনেকুৱা কথা কেনেকে
In fact, the other,
এবাৰ চোৱাৰ পিছত এবাৰ কথা চাব লাগে এবাৰ they should verify না
yes,
before sending
in
to the
fact,
high court.
the other pages are much worse Lordship. That is, Lordship,
Your petition is in custody since when?
My lord, since 3rd March of 2023, my lord.
3rd March.
No, so, yes, my lord, February 2023. One is from February 26, 23, and one is from 3rd March of 2023.
otherwise they can
My
also
lord,
use the
the
PW.
bail was earlier rejected with the direction that the other evidence, witness of the other after examination of the PW4, Pradeep Shah, and Pradeep Shah as well as my lord, one Monu Shah examined, nothing has made any implicated statement against the Lordship will find the statement, their statement, annexer 4 and 5.
So after that order, as per your knowledge, how many, as per your information, how many witnesses have been examined?
My lord, earlier it was 3, now it will be 5. 5 and
Five witnesses.
as per earlier order, 2 witnesses are not relevant. It was recorded in the previous order, my lord.
Really?
My lord, in para 4 has been recorded that 2 witnesses are not vital witnesses. And it was the observation of this honorable court that Pradeep Shah is a vital witness because the person got arrested in connection with the case only through IMEI number of the mobile set, which was sold to the Pradeep Shah. Pradeep Shah, my lord, says different thing, my lord.
Now Pradeep Saha is already examined.
Examined, my lord. That is a PW4, my lord. Lordship may kindly have a look at page 17. Page 17 of my main petition. This deposed, my lord. Lordship got it. I do not know the informant of this case. I do not know the deceased. I do not know the accused person standing in the dock. I purchased one mobile handset from a passenger. I gave the mobile handset to my younger brother. The mobile handset shown to me totally is different, similar to the one which I purchased. But I cannot say today that the mobile handset is the same which I purchased earlier. I do not know anything else. My lord, in cross, he said, I do not have any document to show the purchase of mobile handset. I purchased the mobile from an unknown person. I have not purchased the mobile handset from the accused person standing in the door. No, my lord, very clear evidence, my lord, no implication.
Sharma, so 4 and 5, 2 more witnesses now.
Lordship, I was not aware of the earlier detection, but in any case, Lordship, I have seen now, Lordship, that they are under custody since 23. That's a long time, Lordship. Considering the fact that it's a murder case also, Lordship, a very long time.
Long intercession of 3 years cannot on that contest because
Yes.
it's a murder case.
Yes, it's a murder case. Lordship,
Where from it has to get your this case is from which district?
Bilasipara.
Bilasipara, my lord. My lord, there another witness, my lord, PW5. He has also made no implication against the person, my lord. He was also examined as PW5 later on, my lord. After the
Yes,
order
very-
rejection of the bill.
The brutal murder, in fact,
Yes.
the person was
Yes.
killed.
It is there. Lordship, otherwise, Lordship, then once again requisition, Lordship, from the registry. Only the deposition and the status report.
From deposition also you have already annexed here.
My lord, yes,
4 and
certified
5.
copy, certified 4 and 5, my
4
lord.
and 5 you have already
Yes, my lord.
annexed. And as per your information, 5 witnesses examined.
Yes, my lord.
Now 1, 2, and 3 we required now.
My lord, 2 witnesses are irrelevant as per earlier order. Lordship has recorded in paragraph 4 of in the earlier order. So 5 plus 2, my lord, 7, then my lord.
And one more thing, Lordship, yesterday the case was fixed for evidence. So we do not know whether yesterday any witness have been examined or not.
I have no instruction, my lord. So, my lord, considering the length of detention, my lord, the person from whom the mobile was suspected to be purchased, they have made no allegation, my lord.
There are some materials. Actually, I have not gone through the entire record. The person was brutally killed.
Yes. Lordship, can
And
call for
that from the handset, mobile handset was sold
yes.
after committing the murder. These kind of things are there.
And they absconded also, Lordship.
Absconded.
They were arrested
There
from outer
they
state.
got arrested.
Yes.
That is the main issue.
So what we can do is,
And
Lordship,
if
Lordship
okay,
can
then.
call for a updated status report if possible. Along with
Yes, return counsel.
My lord,
And also-
both are hailing from West Bengal.
Scan copy of the is recorded, but it is very surprising that the scan copy which has been sent to its court is not visible, especially the evidences so far recorded by, especially the testimonies of the PWs recorded by the session judge. In view of this, the registry is hereby directed to get the visible scan copy, especially the evidences of PWs, and also the present status report may be called. Further, the stay is hereby directed to issue and further the learned session judge is hereby directed to furnish the scan copy of the legible scan copy of the witnesses as well as the present status of the case record. Strictly they keep on or before the next day of the without what 5th of February. We're listing it on 5th of February.
Your Lordship, this scan copy I have seen, the CD part is not in the case diary, in the PCR. That will be
CD
necessary.
part is not there.
CD part is not there. Because Lordship, they are submitting on the violation of 47 and 48. So that part will be in the CD only, Lordship.
Lordship, this matter may be taken up after some time. We have some submissions to make, Lordship. We have some submissions to make, Lordship. Taken up after some
After
time.
some time, Lordship, today is a hectic day. I have duties in other courts also, Lordship.
After 1 2 items.
Like the CD part come, Lordship. Then a date.
We're facing immediate shortage.
Lordship.
But next week may not be possible. Let it be on 2nd of February. 2nd of February.
I'm sorry, because of this traffic jam.
Now he is saying that the scan copy which has been received, especially the CD part is not there. And we need the CD part. Especially CD part is required.
But
So we are fixing it on 2nd of February. This next week most probably it may not be possible. Let it be on 2nd of February. From where it has to come? From Guwahati itself?
Guwahati.
Yes, my lord, it is Guwahati itself.
Okay.
Otherwise, anyways, whatever you
Scan copy.
The epic is there for this Ganesh Puja.
They have diverted the vehicles.
Yes, that was. Have a seat, Mr. Biswas. Take rest.
Yes, no, I understood now. The CD part of
That is,
the,
yeah, because that is your main case is on based on 47, 48, I think. No,
absolutely,
as per his
more particularly 48.
more particular 48. So that's why he think that it's necessary, I think, to go through that. Anyway, we're listing it on 2nd of February.
2nd of February.
Heard Mr. M. Biswas, the run conflict for the petition, also heard Mr. P. Sharma. The learned additional PP appearing on the interest bill. Scan copy of expire. Scan copy of the TCF has been received, but it is submitted by Mr. Sharma that the CD is not available in the scan copy of it. In view of this, the registry is hereby directed to call for the scan copy of the case diary from the concerned court and has to be and needs to reach on or before the next deadline. It is the matter on 2nd February. Second. Okay, 2nd.
I'm deeply.
Please report. Your Lordship, we have filed an interlocutory application in this matter. The registry had identified certain defects. We have cleared those. And your Lordship may allow the interlocutory application to come on record.
It was online, no?
It's yet to be registered. We've just cleared the defects.
There are some defects found.
We have cleared the defects. It is yet to be registered. I presume it will be registered today, Your Lordship.
We also not served to us, madam.
Copy already served to you? No.
Not
But there was some defects. The defect that you have
before, Lordship, before filing copy has to be served.
Your Lordship, we had prepared a copy, but the registry did not intimate that service was required, but I can serve a copy right now. No.
That's why maybe it's under defect, I think. But
We have cleared the defects now, Your Lordship.
until and unless serve the copy, it will under defect.
no before at the time of before filing you should get the copy.
Yes, but
I will serve a copy right now.
You are MS MDAS?
And that's it.
RMS MDAS, the learned from the petition. The P. Raman, the learned counsel for the respondent is submitted by MS DAS that they have filed one interlocutory application, but that could not be raised due to some things, and after clarification, the registry is supposed to register and seat. In that context, Mr. Rahman submitted that they have not received any copy which could have been furnished to them before filing. has thus however submitted that she filed. Is the matter accordingly, after 1 week will do, or
Your Lordship may kindly have it in the second week of February, on the 10th of February, if permissible. The lead counsel will be out of station starting today till the 9th.
with the addition to the lead counsel to take the interlocutory application into the weeks.
Well, one date, we may.
10th of
10th of
February.
February.
10th of February.
Obvious.
Deeply obliged.
Sorry for the inconvenience, madam. May I check the records, my lord, of the LCR?
Hmm?
Can I check the records, madam?
You can in the record.
My lord, in this case, I am seeking an adjournment due to some subsequent event. What happens in this case, my lord? The impure.
The last occasion you say there are some electricity problem, you have cut and this
that
goes
was-
on that.
So that mistake has been disposed of.
Hmm.
During the pendency
The
of
order
this.
has been passed in that same case.
No, that is a different order is passed and directed to restore the electric connection. So I am not connected with that order. I am connected with my two petitions by which I wanted to examine the petitioner as well as I sought certain documents for production of certain documents. That petition was rejected, against which I have came before this honorable court. And this honorable court also issued the notice they have appeared, a sent copy has been called for. But subsequently on 6/1/2026, my lord, whole in this case has been disposed of. Though a part of that order has been challenged by me before this honorable court. So how the whole case can be disposed of? So, my lord, I want to have, I want to take some time, my lord, to go through the relevant law. See whether in the disposed this case, this what will be the status of this revision petition? In fact, my lord, the learned court should have registered two separate mistakes on my petition, but he amalgamated my petition along with their electric connections, my lord. So, my lord, I pray money sometime after 2 weeks, let it, this matter may come up. I shall make the submission.
Your petitioner, now the electricity connection is there with you now.
This matter was only regarding, suit was only regarding electricity, nothing else. And interim order was passed in 2030. 2005 to 25, they have disconnected. Now what final order has been passed, they have been directed to restore. And police is directed to see compliance of the order. That order which was passed in 2013. And this matter suit is in argument stage. At this stage, they come against two petitions. They wanted to cross-examine the deponent, but the person whom they want to cross-examine, he is not the deponent. Somebody else. He is the original plaintiff. His husband is conducting the case. He filed affidavit. He gave evidence. Everything right from the beginning. He is doing everything. Now they want to, because she is the wife and she the plaintiff. She must be aware, so she may be examined at their option. And second petition which was rejected was this, Your Honor. They filed one petition that my this returns I should file. It is simply a matter of restoration of electricity. For ejectment, they have already filed a separate suit. That is in argument stage. Already filed. Separate suit is going on. That is in subletting, defaulter, and all. They are not taking this ground there. In my electricity, just to restore. Till today, they are interested that my electricity should not be restored. Till today, they are trying. In spite of injunction order, they are trying that my electricity is not restored. This is the second suit which they have already filed for my ejectment, and subletting is a ground there. Now for the in this electricity case, since they have sublet, they are not entitled. And Honorable High Court, Supreme Court says till a tenant is evicted, he is entitled to all the facilities. Their law is there. So what remains here?
And then after the order passed by the learned trial court below in those missed cases, now your electricity has been restored?
No, they will not allow. Even in spite of the order, directing them to restore, directing the police to see compliance, it is not restored till today. Till today, it is not restored. It was disconnected, Your Honor. Just a minute. It was disconnected before puja on 18/9/25. I am without electricity in the heart of the city, running my, it is my shop here. And they have so much courage. They are, in spite of contempt, the contempt is a definite matter. I will take 150 on court power. When they court power injunction in 2013, court has no power to direct the police to see compliance. Court has not passed any order. Court again directed them, you please restore. And police to see whether it is restored. Already police report is there. Previously an interim direction was passed, directing me to take temporary connection because my bill is hardly 500. For that every month I am to pay 7,000. I went to electricity, filed application, they came, he did not allow. All these things are there. His brother, my 3 other landlord, he is one of the landlord. They are saying he has disconnected electricity. ASCB say we have no objection in giving electricity. Police say, police report was called. Police say they have disconnected. There is no electricity and they are not allowing the ASCB to restore the electricity. All these things are in report.
But this CRP is not related to those electricity connections.
That 2 petition in course of that miss case, which they filed prior to final hearing, those were rejected. Against that they have. Now that petition has already been miss case has been disposed of, and what direction is only to restore, nothing else.
So
what
those
is
miss cases have already been disposed of. Now what is this?
now
this
nothing
case?
remains. So that
Nothing
why he is
remains.
pursuing, I don't know. And it is a revision, Your Honor.
For that matter, I'm
Power of the
adjournment.
court under 227.
Let this matter make
227 is
for
very
2 weeks.
limited, Your Honor.
Because during the pendency of
Because in the
CRP
pendency of
yes, madam.
there was no such stay order.
Court especially passed last order that trial court is not debarred from
Debarred from
passing.
any, yeah.
Because that day I thought he may go and some disturbance he may create. So Your Lordship passed that order. And in the meantime, court, there is this order,
Yes,
full
it is
detail,
order
that
is
order is
yes.
there, you know. You may kindly see this order is there. It is disposed of last 6.
What happens in this case?
Yes, yes, last order was there, yes.
Yes, it is there. I'm just giving you.
What happens in this case, Manor? That this case was fixed for order relating to this electric connections. So this honorable court passed the order. There is no bar to passing any order, order. But this honorable has not directed to dispose of the whole of the mistakes. This honorable directed there is no bar to pass any order fixed for order on the next. That was relating to the disconnection or reconnection of electricity.
See, detailed order. I'm just giving it.
Court notes. So this honorable court, after hearing, the court has disposed of, passed the necessary order relating to this electricity. Now, whether electricity is restored or not restored, that is not the subject matter of this honorable court. There are other remedies they can approach, because I have never
Why it is a subject matter of this court?
Huh?
You're saying this the electricity connection is restored, not restored. These are the subject matter of which court?
of the trial court.
Trial court
Of the
only,
trial,
yes.
yes, madam. Of the trial, not this court. So I am connected only with the petitions, whether the honorable court rejected my petition in accordance with law. That is only my submission, my lord.
Okay,
So
anyway.
after 2 weeks,
Lordship, what happened? His conduct, Your Honor, will see. He's coming to this court again and again. Filing there.
My lord,
There also he filed
my
stay
lord, I
petition.
have
Yes,
objection.
yesterday it was rejected. He filed that
My-
order may be stayed. I will move a civil revision petition. Trial court yesterday only rejected that petition.
my lord,
But
my lord,
he is somehow.
I have some objection.
Somehow.
my lord. He is
Now
my
the question is, suppose, I don't know, I have not done the entire record, but
He
the
doesn't
question is that
my
if suppose
conduct,
there
my
is a-
lord.
no, if suppose there is an order of restoration of electricity connection,
Yeah.
you can restore the electricity connection. The matter of eviction, definitely.
That is the
yes,
different thing, my
eviction
lord.
suit is there only, it is the
Ah.
ultimate stage.
But
Okay.
there are two orders. Man. Order is directed to the APDCL to give temporary connection. That order. Another order was this that landlord, including all the landlord, I am one of the landlord, to restore by directing the OC Barole Muke to assist them. So there are two orders. So there are the confusion because the court has directed.
Confusion.
First order is merged with the final order. Your Honor. Interim order merged.
My lord.
That was interim order.
Let this matter may come after 2
There
weeks.
cannot be such confusion.
There is confusion in the mind of my learned friend, not in the court and all.
heard Mr. S. Sansit also for it. We did and did not. This submits that he needs some time to put some actions. But we- Okay, Mr. Jain did submitted that this case has already been disposed of, directing the petitioner for connected restoration of the age. But Mr. Sansit has submitted that as there is some, he needs some time to go to the record and those petitions for the doing the submission made. How many weeks you need? 2 weeks.
After 2 weeks.
And get the matter relisted after 2 weeks as an dispute by the registry or any date. Because there is no such order. If in that other case, the eviction suit, it is in argument stage.
It is argument.
This is not connected with this one.
No,
and
no,
this is-
that took, he filed rejectment suit, I filed declaratory suit for restoration of electricity. There are two different
So that is for the argument stage.
arguments.
After
Lordship, this order that is disposed of already miscase that you know
I have already passed the order.
Order,
This
recorded.
case has already been
reported.
Apa number to lift. Your miscase, that miscase number is I think 454, na?
454
454.
of 2020.
And citing with the miscase number submitted that mistake case number 454 of it already been and put me at site.
Much more like.
May it please, yes, madam. Well, here in this case, a civil suit was filed, madam, before the Munsif against the present respondents, seeking a decree for declaration of right title interest, recovery of possession, and for other consequential reliefs. My lord will find that suit at page number 16. My lord may need not go to the plain. Thereafter, my lord, the respondents filed a written statement. Along with the written statement, they also filed a counterclaim, seeking certain prayers, my lord. Thereafter, what happened, my lord? They filed a petition that my lord will find at page number 71.
Yes.
Here in this case, my lord, the present petitioner's land that was acquired by the district collector, Sri Bhumi, madam, for the purpose of certain public purpose, my lord. Bharatmala project. So, my lord, thereafter what happened? They filed a petition that my lord will find at page number 71, saying that, my lord, the part of land that was acquired by the government of the petitioner, that is also a part of the civil suit, and that should be stayed. The compensation amount should be stayed. Thereafter, my lord, on the very same date when this petition was filed, my lord will find at page number 75. The learned court of Munsif, my lord, although I am not a party to the suit, without hearing me, has stayed the disbursement of the compensation amount. That my lord will find at page number 70. May I just read out the order? Order dated 28 to 2025. Case record is put up on the strength of petition number 363 of 2027, /27. It ought to have been 25, filed by the defendant side, praying not to disperse any compensation amount to the plaintiff or any other person under Bharatmala project relating to the suit land. Upon considering the submissions made by the learned counsel for the defendant and perusing the materials available on record, it is evident that the land in question is the subject matter of the instant suit, which is pending adjudication before this court, and the suit land attracted dock number 293, patta number 288, khatia number 135, which allegedly falls under the Bharatmala project. Since the matter is extremely urgent and the fact that the land in question is the subject matter of the instant suit pending before this court, it is necessary to issue immediate directions to prevent any irreparable loss or complications. It is further observed that directing the disbursement of the compensation amount at this stage may prejudice the rights of the defendant and affect the fair adjudication of the matter. Hence, to prevent any injustice, the court deems it necessary to restrain any disbursement of the compensation amount until further orders. In view of the extreme urgency, the order is passed without hearing the plaintiff, although the plaintiff is not in possession, and without hearing the petitioner also, as non-granting of immediate relief may render the suit infructuous and lead to injustice. However, such an order does not cause prejudice to the plaintiff since the matter remains sub judice before this court. Accordingly, the district commissioner, Sri Bhumi, is directed not to disburse the compensation amount to any persons until further order of this court, my lord. Thereafter, my lord, we came to know that the present petitioner came to know that this order was passed because we are not a party to the suit. So what we did was at the very next page, page number 77, we immediately filed an application under 151 of the CPC for vacating of the said order, my lord. Similar petition was also, my lord, our contention was at paragraph number 2 and 3. May I just read out? Paragraph number 2 and 3. That the suit lane of the instant suit is appertaining to new dock number 498 under patta number 180, Khatian number 351. The counterclaim of the defendant's counterclaim is also in respect of dock number 498, patta number 180, Khatian number 354, Moza Suprafandi. That so the land of the third party petitioner covered by new dock number 293 under patta number 288 of Moja Lakharkhandi is no way involved in the instant suit or counterclaim. The third party petitioner and others have been selected for compensation against the acquisition of land under Bharat Mala project. The defendant's counterclaims have personal grudge against the third party petitioner. So to stop the compensation of the third party petitioner, the defendants have filed petition number 363 of 27 dated 28 to 2025 before this learned court, falsely stating that the land of dock number 293, patta number 288, final Khatian is the suit land of this suit, and by misleading and misguiding the learned court has obtained the restraint order dated 28 to 2025 without hearing any side. Subsequently, the defendants have submitted the order dated 28 to 2025 to the District Commissioner Sri Bhumi and approached not to disburse the compensation amount to the plaintiff or any person against the land of dock number 293, patta number 288. So the District Commissioner Sri Bhumi has stopped the disbursement of compensation money to the third party, that is the present petitioner, for which the third party petitioner has been suffering very badly. The order dated is misguiding and misleading order obtained by the defendant fraudulently, and as such, the third party petitioner has prayed for setting aside the order dated so and so. In view of the above, it is humbly prayed to put up the case record and upon perusal of the record so and so counterclaim set aside and vacate the order dated 28 to 2025. This was a limited prayer, my lord, that without hearing us, without us being made a party in, and without the dock number and patta number being a...
You are not the party in that suit.
No, my lord. In fact, in the order dated 28 to 2025, my lord, itself says that, my lord, without hearing the plaintiff or the petitioner, my lord. It is crystal clear, my lord. Secondly, my lord,
No, you are not the plaintiff in that suit.
no, I'm not the plaintiff. The plaintiff has got no interest in my suit, my lord. The suit pertaining to dock number 293. Because he is in 497. There's a similar petition was filed by the plaintiff also for vacating the order dated 28 to 2025. Subsequently, my lord, at page number 91, annexure 12, the impugn order was passed.
Yes.
The operating portion is at page number 92, my lord.
Page number?
92. Next page. Upon consideration of the pleadings and materials placed on record, it is evident that the validity of deed number 2978 dated 19/5/2004 has been challenged in the instant suit. The said deed includes land covered by dock number 293. Although the dock number is not explicitly mentioned in the schedule of the pleadings, the connection between the impugned deed and the dock number in question is established through the Jamabandi records submitted by the defendant. It is a settled principle that when a deed is challenged in the suit and that deed pertains to a particular land, any order concerning the subject matter of the deed must include all the properties described herein. Therefore, until the issue of validity of the deed is adjudicated, any compensation relating to land covered under the said deed must be withheld to avoid prejudice to the outcome of the suit. Accordingly, this court finds no merit in the petition filed by the plaintiff petitioner. And as such, my lord, my application as well as the application filed by the plaintiff, that was dismissed.
But that petition was filed by the plaintiff.
plaintiff as well as by the present petitioner. Now, my lord, while passing this order, my lord, my main ground of challenge is that the court has no jurisdiction to pass this order, staying the disbursement of the compensation amount, my lord. Because why, my lord? My lord may kindly take up the right to fair compensation and transparency of land acquisition. Right to fair compensation and transparency.
Yes.
I will take up section 63. Page number 37. I'll just read out section 63. my lord. Jurisdiction of civil courts bar.
Yes.
No civil court other than High Court under Article 226 or Article 227 of the Constitution or the Supreme Court shall have jurisdiction to entertain any dispute relating to land acquisition, in respect of which the collector or the authority is empowered by or under this Act, and no injunction shall be granted by any court in respect of any such matter. So, my lord, suit is barred. Since suit is barred, an order of injunction cannot be also passed, and no stay order can be passed, my lord. Section 63 itself, my lord, is very clear that the jurisdiction of civil court is barred when land is acquired, and the power is conferred only before the, my lord, the district collector. And the district collector may refer it to the reference court. That was the law before the coming of the this Act also, my lord. And in the other Act also, my lord, Land Acquisition Act 1894 as well as 63 Act. However, section 63 has been, my lord, specifically included after the amendment in the year 2000.
The question of acquisition definitely is a part of under
My lord.
section 63, but it's civil.
My lord.
But now the question is a bit different because their claim is that yes, the land which has been acquired falls under the suit. That is their claim.
Now that
That's
is,
why it has been-
my lord, may now kindly come to the prayer portion, my lord. Prayer portion of the suit, my lord, which my lord will find that the plain started page number 16. And the prayer and the schedule of the land is given at page number 32 and 33 of the plain. Here, my lord will see that schedule 1.
Hmm.
The patta number is 180, new duck 498.
Hmm.
Thereafter, my lord, schedule 2 is 180, dark number 508. These are the two ducks, my lord. 498, patta number 351, patta number 180. Whereas, my lord, our dog is 293 under patta number 288. We have specifically stated in our petition, my lord, page 77. So there is no tally, no corroboration, my lord.
Your dog is too.
My dog is 293 under patta number 288. Now, my lord, they have also filed counterclaim. So let us see the serial of the counterclaim as well, my lord. At page 54. Schedule 1 that they have given is dark number 508, patta number 180. Schedule 2 is dark number 508, 498 new, patta number 180. And Schedule 3 is also, my lord, DAG number 508, Patta number 180. So there is no mention of Patta number 288 and DAG number 293 in the schedule of the plaint as well as in the schedule of the counterclaim. So, my lord, now even if assuming, my lord, that they are fair in the counterclaim, which they have, the court have held that, my lord, at prayer number 3, at page 53, that they have sought for a declaration that the deed of partition deed, that is document number 2978 dated 19/5/2004, that is not valid, that is illegal. And the present DAG number, that is 293, pertaining to the present petitioner's land, that falls within that said deed, my lord. That is why, my lord, the court has rejected my petition, both the court. Now, even assuming that, I have got the, my lord, the deeds, the agreement. I have marked also, my lord. Nowhere I have been able to find DAG number 293 of Patta number 180, my lord.
This is whose
This deed they have challenged, my lord, in the counterclaim. And because of that, the court below has rejected my petition, my lord. I have marked all the DAGs number, my lord. No mention of DAG number 293 under Patta number 288 is there, my lord. From where the learned court has made out a case for themselves, my lord, I don't know. Now, my lord, that being the position and situated thus, my lord, where was the urgency to pass the order dated 28/2/2025, my lord, without hearing us, without being us being made a party, my lord? Since the DAG number does not fall in any of the schedules as given in the plaint as well as in the counterclaim, and neither in the partition deed. So, my lord, there was absolutely no question that, my lord, the disbursement of the compensation amount acquired for the land from me, my lord, that could have been stayed. Secondly, my lord, as I have already read out section 63, that is specifically clear that, my lord, the jurisdiction of civil court is barred and civil court cannot entertain any suit with respect to any land that has been acquired by the collector. And thirdly, my lord, the principles of natural justice has been violated because, my lord, without hearing me, the order dated 22/2025 was passed. In this regard, my lord, I have two judgments, my lord. Wait. 2013 PSCC, page 66, para 13. May I read? It is clear that Land Acquisition Act is a complete code in itself and is meant to serve public purpose. By necessary implication, the power of civil court to take cognizance of the case under section 9 of CPC stands excluded, and the civil court has no jurisdiction to go into the question of the validity or legality of the notification under section 4, declaration under section 6, and subsequent proceedings, except by the High Court in the proceeding under Article 226 of the Constitution. It is thus clear that the civil court is devoid of jurisdiction to give declaration or even bare injunction being granted on the invalidity of the procedure contemplated under the Act. The only right available for the aggrieved person is to approach the High Court under Article 226 and this court under Article 136 with self-imposed restrictions on their exercise of extraordinary power. So, the Supreme Court is itself very clear, my lord, that the civil court jurisdiction is barred. And situated thus, my lord, the Munsif Court would ipso facto cannot confer any jurisdiction upon itself, my lord, saying that, my lord, the disbursement has to be stayed. Even, my lord, if the hierarchy of is considered, my lord, Court of Munsif, my lord, directing the deputy collector, my lord, not to disburse amount, that itself is illegal, my lord. So my respectful submission is, my lord, this order, the impugn order, that should be set aside, my lord. And if they are at all aggrieved, let them appear before the collector and file appropriate application, my lord. And thereafter, my lord, the deputy collector, district collector will send it to the reference court, my lord. That is my respectful submission.
May I please? Let kindly come on page number 91, Your Lordship. 91. The middle portion, Your Lordship. The opposite party defendant file objection and a subject submitted that although DAG number 293 is not specifically mentioned in the schedule of the plaint or the counterclaim, he has in his counterclaim sought a declaration concerning deed number 2978 dated 19/5/2024. It is pointed out that the said deed pertains to the land situated at Moza, Lakharkhai under Khatian number 135. The defendant has also submitted a photocopy of the Jamabandi which shows that deed number so dated so correspondent to DAG number 293, Your Lordship. So the Sweden has been arises out of the deed 297 of 2024, Your Lordship. And in our counterclaim, my lord, counterclaim written objection, Your Lordship, kindly come page number 85, Your Lordship. 85, paragraph 9, Your Lordship. That the land of DAG number 293, Pata number so Khotian number 135, Moza Lakharkhai is a part of the land of the elect petition, partition dated for whom the answering defendants paid for cancellation, and the elect deed 2978 of 2024 is the subject matter of the suit. The third party petitioner mutated the land of DAG number 293, Pata number so Moza so in his name on strength the elect 297, that means deed, elect deed 2978 of 2024. So the learned court rightly passed an order dated 28/2/2025 in respect of the land elect partition deed. If the learned court be pleased to vacate the order of restraint void order dated so on the petition of third party, the defendant shall suffer loss and injury, Your Lordship. So we are the defendants on that, Your Lordship. We are here, my lord, respondent number 1 to 5 and 9 and 10, Your Lordship. And respondent number 5 is professionally an advocate, my lord. So, my lord, if I may be allowed, my lord, Parhat may be granted, and the Minal Uddin, the respondent number 5 will be argued the case. Objection will be raised, Your Lordship.
My lord,
Next date, any date, Your Lordship.
my lord, this is, my lord,
Maybe
after hearing everything, my lord,
but
they come up with
after
this.
hearing from the petitioner side, my lord, we are respondent, my lord.
First beginning only you could have submitted all these things.
Look.
We don't have any issue in adjourning the matter, but the question is that we have heard the matter, you remain silent, and now you are saying that.
No, my lord,
it's going to
I
argue.
think, my lord, Parhat may be.
No, I won't make it part hard. Part hard is
Well,
will create problem.
Problem is that the land has already been acquired. I am landless now. I have got no place to stay, my lord. And my amount has been stayed, my lord.
The amount.
I have got nowhere to, I have no money also, no place also, my lord.
Yes, ma'am. And my, as per my information and instruction
And we
has
are
been
trying to
come
delay the matter.
from the Sri Bhumi, Your Lordship. Deputy Commissioner Sri Bhumi, so my lord, I think.
Plus, the deputy collector will proceed as per law, my lord. But since there is an order of stay that has been illegally passed, my lord, I am stuck now, my lord. I'm hanging, my lord. I'm neither here, neither there, my lord. My lord has already heard the matter. My lord has already seen that, my lord, it is barred by jurisdiction, as well as, my lord, the subject matter is not the subject matter of the suit, my lord. I've already filed the partition deed, my lord. Please,
Really. So what do you want to submit?
My lord, as per my instruction, my lord, one instruction has been come from
What
the
is that?
from the Deputy Commissioner Sri Bhumi, Your Lordship.
That is not with you now.
Now, I don't know about the instruction, but one instruction has been come, who is the party number 11, respondent number 11. District Commissioner Sri Pami Alot.
District collector will proceed as per my lord's instruction, my lord.
Instruction may be required, I think, as per my.
Let it remain, my lord. Order may be passed, my lord. There is nothing, my lord.
How can we be paying for any adjournment?
Then let it remain part hard, my lord, because I have already.
Part hard will create problem otherwise.
Part hard?
Because bench may not be available.
Any date the bench is available, my lord.
Yes. Yes, obviously I have heard.
My lord, that is
at
fine, my
length.
lord.
Yes. Yes, my lord,
My lord has given a patient hearing, my lord. Otherwise, already 30-40 minutes have gone by. Precious
short
time
date
of the
may be
court has-
given. I have not section on that.
This has been pending for almost a year now, my lord.
Mr. I.
Iqbal.
Sorry, A. Iqbal. Heard your
Yes, Islam.
Yes, Islam.
125.
On the prayer made by Islam, the matter is HR. The matter will be listed on 11. 11 to 25 as a part.
Mass operation.
And yes. The matter will be about after the 7 weeks. And appears on call for the advert. The matter be accordingly listed after 7 weeks.
Okay, item number 10.
12.
Item number 10 was Leonard.
Yes, okay, 10, yes.
In this case, I am paying a 3 days time for taking step upon the respondents.
We have not taken steps yet.
Published.
Hard, Mr. Hard. Yes, yes, just wait. So good name?
P. Goswami.
Hard MSP Goswami. KK Patra. KK Patra, the learned counsel for the applicant. Submitted that inadvertently they could not take steps for the response. It's some time. Prayer allowed, directing the respondent with appellant to take steps for the respondent to speak. List accordingly.
Published.
Where? 12 also your opinion?
Yes.
Yes.
Step has been taken. Any is awaited. I pray for time.
I with all steps I can say about directly it is submitted by insurance appearing on the that steps could not be taken according to its prayer that engaged on with the steps.
My lord.
Notice the response to speak.
My lord, regarding item number 5, Actually, I'm appealing for the government. Now, what has happened, my lord, something serious has happened, so I have to point it out. My lord, it doesn't concern the parties, it concerns the court. I was not present when the case was taken out because I was engaged in another court. So I have to point out the serious mistake, Mr. My lord. And it has nothing to do with the parties and the case. It is something the administration.
Okay,
Now,
now,
what happened
no
on
issue.
7/1/25,
No
my
issue.
lord, on 7/1/26, my lord passed an
Listen,
order.
listen, one.
Yes.
About the Sajini question is that we had heard at a length both the parties,
Yes.
but the respondents had paid for an adjournment, so we are listing it 11 February. We are listing it on 11 February. So on that day, we'll hear your submission.
But this thing, my lord, because it concerns my lord's order. So that order, the date, my lord passed on 7/1/26. That my lord must be already remembering because it's very recent and it is in our note also. But the order in the website, it is showing 7/1/25. So that is something very serious, my lord. Because it will
Okay,
reflect on the
Doctor.
and my
We'll
I'm
see.
passing the order. One year, my lord. Because absent-mindedly it must have happened.
We'll make correction in the website. Main order is corrected.
Yes.
In the main order, it is correct, but
Yes.
somehow most probably there is a mistake. So we'll
So
make
it will be on 11/2/26 next.
yes, we make a correction on that.
My lord, my name may be recorded.
This is correct. That one is not.
My name may be recorded that I have completed.
It's here as info layer. Yeah, keep on. Very nice. There are matters for hearing on submitted that he is read for the considering submission made by learned counsel for the newly engaged counsel, Mr. Patil, matter be adjourned. Further with a direction to the registry to reflect the name of Mr. Pierre Patil in the cause list, in the panel in the cause list for the applicant. 17th of February will do.
Lordship.
Okay.
Obliging. My lord, please. My lord, I am appearing for 16, item number 16.
Your appellant number?
My lord, I am for the respondents, my lord, in this
Respondents,
case.
yes, yes.
My lord, I'll be fair, my lord. Are you there for 15?
No,
You're
I'm
for
for
the
the 17. No, no. Sorry, I'm for the 17.
1 minute.
Oh, you're for the 17.
My lord,
16, 16 could pass the
RC Pal sir was there, my lord.
Mr. Arsipal was
Yes,
there.
my lord. But he has some difficulty. He had asked me to fix the matter at 2 p.m. if convenient to this honorable court.
No.
My lord, on that case, my lord, I'll point out if my lord permits me, just small thing. There was out of one accident, 2 EC cases were filed, my lord, 14 and 15. For the 14 of 2018, 2 EC cases were filed. If my lord just for a moment turns to page number.
No, what had happened?
So my lord, the other analogous appeal is not before this honorable court today, my lord. So my lord can, that is MFA number 28 of 2020. That is an analogous case, my lord. That is
MFA?
28 of 2020. Today, 27 is there.
Yes, 27 is here.
The analogous case, that is MFA number 28 of 2020, is not before this honorable court.
These are out of same accident?
Out of the same accident, 2 EC cases were filed. Against the 2 EC cases, 2 MFAs were filed. My lord.
MFAs are.
My lord, if convenient to this honorable court.
In the other MFA also you are appearing?
Yes, my lord. I am appearing for the respondent, my lord.
And Mr. Paul is also appearing?
Yes, my lord. He is also there. 7th of February, if convenient to this honorable court, my lord. This is the first Saturday.
No. Though it is a Saturday, working Saturday, we are listing a limited number so that we can do our work. There is a view for opening the first Saturday, there are
My lord, in this case, we have
some reason behind. So
50% is also not released, my lord, in this case, 2020, 18 accident, my lord. Any,
no, we are not done that. Segment we are not fixing.
My lord.
That's what I'm saying.
any other, my lord, date may be convenient to this honorable court?
We have fixed the many matters on 10th and 12th. So
My lord.
at best it can be fixed on either 17th or 19th. Maybe on 17th or 19th.
My lord,
17 will do for you. 17 will.
my lord, 19th on that case, my lord, I have some
19.
outside matter 19th. My
Right.
lord. My lord, MFA 28 also be listed, my lord, on that
Yes,
day.
yes, that's what I'm saying. Mr. The land the minutes submitted yesterday. The learned counsel for the respondent that due to some personal inconvenience to police appear before the court at present. Further, he submitted that one more MFA is filed, which arising out of same accident, being numbered as MFA
28,
of the
2020.
2020, and accordingly, paid released the both the matters together. Considering the submission made by Mr. Day, date MFA 28 of 2020 be listed along with the present bill on 17th.
19th, my lord.
You also mean
19th.
19th.
Deeply obliged.
My pleasure, Lordship. I'm appearing for the item number 17. I'm appearing for the respondents.
You are for the respondent.
Respondents.
Appellant, you are for the appellant? You come this side.
Oh.
Yes, you are for the appellant. Then, yes, what
I'm
is
the respondents.
Yes, what do you want to submit?
Your Honor, the matter may be fixed after March of last week, 26, 27.
No, you are led by any other counsel or you're dealing with this case? Your name is not here.
Yes, I'm appearing on behalf of N. Alam.
And Alam. So where is your counsel?
Your Honor, he is in other courts.
He cannot take up the hearing today.
If possible, after 2.
2 may not be possible. After 2 may not be possible. Mr. Hawk, otherwise you are ready.
My lord, only simple question of law, my lord.
Okay.
Any record was also not called for because the
Record was also not called.
because the question of law is very simple.
Simple.
Regarding maintainability.
2 p.m. may not be possible. Actually, I have some problem, personal problem in fact. Otherwise, it could have been heard if your counsel is ready.
Now.
Now it is not possible for him.
May I ask one?
Or any other day next week, if possible.
If possible, then March last week. Actually, my senior will be out of station.
Fine.
Mr. 17. Mr. Canpop. You are MS?
F. Sultan.
F. Sultana and very Sultan. Council. You are saying on last week of or first week of March?
No, last week. After
Last week of March.
Yes.
26 March.
26 March.
That is on Thursday.
26 March.
Yes.
26th of March with a direction to both the parties to proceed with the hearing on the next
Office.
Please, your lordship, Your Lordship, my senior is on leg. She's currently at a final hearing in the Revenue Board. She's on the way back. Kindly pass over the matter for the time being.
You are for the respondent?
Yes, Lordship.
Your senior is?
R. Chaudhary, Your Lordship.
Arch. You're not listing it.
Lordship, kindly date me fix, Lordship.
Huh?
Date me fix, Lordship.
Your Lordship, preferably today only, if it's possible for the opposite counsel.
Today, not today. We are not hearing any matters at 2 p.m.
Right.
Otherwise, then in that case, we are listing it on 17th of February because
17th.
10th and 12th is almost good. 17th of February.
17.
Obliged.
Your Lordship. In this case, I'm appearing for the respondent, Lordship.
You're for the respondent here.
Respondent, Lordship. It's a small point involved in this case, but the appellant is absent.
On the last occasion, they were present or?
In the last occasion, possibly, Lordship.
This number.
Be absent. It's not. Appellant absent. 10 for 25.
But 19, 12, 25 last date,
Oh,
they were
yes, yes.
present. Mr. Islam, as Islam was present. And appears
It's a case of
for
2020, Lordship. Delay was there, that's why.
2020 means?
2020, I was there, Lordship.
IA.
I was there, it was condoned the year 2020.
I was condoned in the year 2024.
IA is of 2020, condonation of delay.
Oh.
Therefore, appeal came before this honorable court being 2024, 30/2024. It's an accident of 2008.
2008?
Yes. Under WC Act, Lordship. Accident of 2008, judgment of 2000. We will find the judgment of. It's a judgment of 2019. Since then, it's lying before this honor, but they are not taking appropriate steps. And steps also, sometimes they are absent, sometimes they are present like that. Specifically, here the matter on 24th of February.
It's a hearing day.
Hearing day.
It's a hearing day. Oh, you are here. Yes, it is a case of, in fact, I is of his, she's saying that I is of 2020. Then the delay was condoned on 24. Now it is pending.
My lord, I have filed this MFA for enhancement, my lord. My lord, page number 12, my lord. The code below, my lord. That is Commissioner Workman Compensation awarded 1,64,000
It's a dead case or what?
injury case. my lord.
Injury.
Injury case. My lord, the code below awarded 1,64,348 rupees, my lord. My lord, as per section 4A of the Workmen Compensation Act, my lord, the claimant is entitled 12% interest from the date of accident, my lord, till the date of releasing the awarded amount, my lord. I want to submit the Supreme Court judgment. My lord, for Supreme Court judgment, my lord.
So basically, your case for is for enhancement.
Enhancement.
It is an injury case.
Injury case, my lord. As per section 4A, my lord, of Workmen's Compensation Act, the claimant is, appellant claimant is entitled to get 12% interest from the date accident till the date of
As per
release.
section, which section you are typing?
4A, my lord. I am to submit for judgment of Supreme Court.
Section, what, which section you have?
4A, my lord.
4A.
Let- There is a judgment of Supreme Court reported in 2014 to SSC 298, my lord. One of the 4 judgments, my lord.
In which para?
2014 to SSC
Ah, yes.
298, my lord.
2000?
14 to SSC 298.
Just a second.
Sabera Bibi Yakub Bhai Sheikh versus National Insurance Company Limited, my lord. Page 10, para 10, my lord. Para 10 and 8, my lord.
Para 10.
Yes, my lord.
The last para.
Last para and para 8, my lord. My lord, here, my lord, may I read, my lord? In view of the aforesaid settled proposition of law, appeal is allowed. The judgment and order of High Court have set aside the appellant shall be entitled interest at the rate of 12% from the date of accident, my lord. This is the relevant para, my lord. Para number 10, my lord. Let para number 8, my lord, page number 300, my lord. May I read, my lord? We have perused the aforesaid judgment. We are of the considered opinion of the aforesaid judgment relied upon by the learned counsel for the appellant is fully applicable to the facts and circumstances of the case. This court considered the earlier judgment relied upon by the High Court and observed that judgment of National Insurance Company Limited versus Musabbir Ahmed and Oriental Insurance Company Limited versus Mohammad Nasir were par aquarium, my lord. That is through want of care, my lord. Having been rendered without considering the earlier decision in Potap Narayan Singh Dev versus Srinivas Sabatu. In the aforesaid judgment upon the consideration of aforesaid matter, the 4 judge bench of this court had held that compensation has to be paid from the date of accident, my lord. There is full bench judgment, my lord. That is Potap Narayan, my lord. I have submitted another judgment, my lord. That is reported 1976 on SSC 289, my lord. This is the judgment of Supreme Court. Full bench judgment, my lord. 1976 1 SSC 289, my lord. I have submitted, my lord. Court judgment. That is one of the 4 judgment, my lord. Here, my lord, Supreme Court clearly stated that, my lord, the compensation has to be paid from the date of accident. That is, my lord, claimant is entitled to interest at the rate of 12% from the date of accident, my lord. My lord, I have submitted another judgment, my lord.
Accident compensation is, interest is all right. Where from you are getting that 12% is there?
Yes, my lord, 12% interest of the awarded amount, my lord.
No, where from you are saying 12%? Hey, workman compensation. For A1.
4A. 1.
No, yeah. Workman.
My lord, I have
That may be
submitted
like-
another judgment, 2012.
This is the
12 SSC five,
Just a
four,
second, just a second.
yeah, okay, my.
This is the old one, Lordship, governed by this act. It's an old matters.
So 12% is there, the act.
Lordship. Only the point, my learned friend has read, the only point is that, Lordship, whether it can be, interest can be imposed from the date of accident or from the date of adjudication of the case, from the date of the award. This is the point. Otherwise, the so far as merit, the award is concerned, quantum is concerned, there is no dispute regarding only this interest part.
So your main dispute is for 12% is all right, but from date of accident or date
The
of
date
award.
of accident,
So that is the main dispute. Otherwise, you don't have any issue on
no issue,
quantum.
no issue, madam, no.
No issue on quantum.
Yes, madam.
No, basically you raised two issues. One that as per section 4A, 12% interest has to be there, and that apart, the compensation has to be calculated from the date of accident, not from the date of award. That is your
Regarding compensation, I have no objection, madam. Only the interest part has not been given, my lord, by the code below. As per section 4A of the.
interest.
Yes, madam. Yes.
Now, these two, now 1976. Yes, what do you want to submit from here? Okay, now another which judgment? 1999.
My lord, 2012, 12 SSC 540, my lord, regarding section 4A1, my lord. Case number, my lord. Case number, my lord, 543, my lord. It is clearly stated. It is quoted, my lord.
542.
543, 43, my lord. Para 7, my lord. 2012, 12 SSC 540. Oriental Insurance Company Limited versus CB George and others. Here clearly Supreme Court tell that
No, in para 7, they said this is the section 4A, what's
Yes,
with
madam.
this
Yes,
example that is discussed. And
Yes,
what
ma'am.
is the view of the Supreme Court?
Supreme Court.
Hmm?
My lord, here the Supreme Court quoted the section 4A, my lord, and para number 8, my lord. The Supreme Court classified section 4A in two categories, my lord. One is interest, another is penalty. A and B.
This case
Para-
is completely covered by this decision, Lordship, Honorable Supreme Court. Only on this point only, point raised by my learned friend, that
Which
interest,
this 2012?
Lordship 2007 to SCC, this one. Paragraph 9. Paragraph 9. Squarely on this point. Paragraph 9, Lordship, may kindly see this. Where from the interest should be calculated. Paragraph 9, Lordship. May I read, Lordship? This
Yes.
interest is payable under section 483 of the Act, that WC Act, Lordship. If there is default of payment, the compensation due on this act within 1 month from the due, it fell due. The quantum of liability under section 4A dealt with by this court so and so case, and the was amended up to so and so 12% in the instant case. The accident took place after the amendment, and therefore the rate of 12% is fixed by the High Court, cannot be further. Lordship, I failed to bring my specs.
Okay, okay. Anyway, I'm just saying. High Court
But the
cannot be
period
quoted.
is fixed by it's a wrong
But the period
by it is wrong.
fixed by is wrong.
Yes.
The starting point is
Yes. On
on
compensation.
on completion of 1 month.
1 month.
Due date, which is
Fell due.
Obviously, it cannot
It
be
cannot be the date of accident.
since no indication is there as to when it becomes due.
Yes,
it has taken to be the date of adjudication of claim that appears for 4A prescribes that compensation under this 4 should be paid as soon as it falls due. The compensation becomes due on the basis of adjudication of claim. This cases involves assessment of loss to the earning capacity of qualified office. Here,
Falling due does not arise. That's from the date of accident. That cannot be from the date of accident. When it is a case of death case, Lordship, that can be from the date of accident. But whereas it is injury, in injury cases, Lordship, from the date of adjudication. That is there, Lordship. And in this case, Lordship, the award was of 13 to 2008. And judgment is of 25/7/19. And payment was made by the insurance company on 21/8/19. That is within 1 month. Payment was made, Lordship.
the award was of 2018.
Award was of 2019, 25/7/2019. Judgment from Kamrup, Lordship. WC Kamrup.
Payment was on?
Payment was on, Lordship, 21/8/19. I have the receipt also. Within 1 month, 25/7/19, then 21/8/19. Receipt to date. Payment for receipt.
So that was prior to the amendment.
Yes,
It was
this is
prior to
this.
them.
Yes. This is the at that time it was prevail. This act is prevail. Now amendment is recently it was done.
No, 12% amendment was?
The 12%, we have no objection. It is as per law. It will be there only. 4142. Within 1 month, we have paid, Lord. Satisfied by award. First line of section 4(3), Lordship, that is there, that the has to be paid within 1 month. And then the clause is there that in case of injury, the interest should be calculated from the date of adjudication, not from the date of accident. That is clearly the division and judgment, Lordship.
My lord, my submission is that, my lord, there are full bench judgment, my lord, which will be applicable, my lord. This is division bench judgment. I have submitted full bench judgment, that is 1976 one SSC.
1976,
289, my lord. And
2007.
this judgment has been relied in this judgment, my lord, 2012, 12 SSC 540, my lord. My lord, para number 10, my lord, page number 545, my lord. This section 4A is inserted in the year of 1995, my lord. I have filed 2008, my lord. The case, my lord, that is WC case, before the Commissioner Workman Compensation, my lord. There are full bench judgment, my lord. Para number 10, my lord, page 545. It is clearly stated, my lord. May I read, my lord?
In 1976, na?
Yes, my lord. This judgment has been relied in the judgment, my lord. That is 2012, 12 SSC 540, Oriental Insurance Company Limited versus CB George and others, my lord. Para number 10, page number 545, my lord. May I read, my lord?
Para number 10. No,
Para number 10.
in 1976, which para you are saying?
My lord, 3. My lord, 1, 2, 3. A four judge bench of this court in Potap Narayan Singh Dev versus Srinivas Sabata speaking through Singhal judge has held that an employer becomes liable to pay compensation as soon as the personal injury is caused to the workman by the accident which arose out of and in course of employment. Thus, the relevant date of the for determination rate of compensation is date of accident, my lord, not the date of adjudication of the claim, my lord. Clearly stated, my lord.
Para 10.
Para 10, my lord. Para 10, there is 3 sub-para, my lord. 1, 2, 3. From para 10, my lord. May I read, my lord? Para 10. The matter once again came up before this court when the amendment introduced in the Act by the Act 30 of 1995. The amount of compensation and the rate of interest were increased with effect from 15/9/1995. The question arose whether the increased amount of compensation and the rate of interest would apply also to the cases in which the accident took place before 15/9/1995. A three-judge bench of this court in Kerala, SEB versus so-and-so, answered the question in the negative, holding on the authority of Potap Narayan Singh Dev that the payment of compensation fell due on the date of accident. In para 1, 2, and 3 of the decision, this court observed as follows. Number 1, the need question involved in this special leave petition is whether the amendment of section 4 and 4A of the Workmen Compensation Act 1923 made by the Act 30 of 1995 with effect from 15/9/1995, enhancing the amount of compensation and rate of interest would be attract to the cases where claims in respect of death or permanent disable resulting from an accident caused during the course of employment took place prior 1995. Number 2, various high courts in the country, while dealing with the claim for compensation under Workmen Compensation Act, have uniformly taken the view that the relevant date of determination of rights and liabilities of the parties is date of accident. Number 3, a four-judge bench of this court in Potap Narayan Singh Dev versus so-and-so, speaking through so-and-so, has held that an employer becomes liable to pay compensation as soon as the personal injury is caused to the workman by the accident which arose out of and in course of employment. Thus, the relevant date for determination, the rate of compensation is date of accident, not the date of adjudication of the claim, my lord. It is clearly stated by the Supreme Court, my lord. Not from the date of adjudication of the claim application, but from the date of accident, my lord. In this case, my lord, Supreme Court dismissed the appeal of the Oriental Insurance Company with a cost of 20,000, my lord, in para number 14, my lord.
It's Pratap Narayan Singh Lordship, that was, it is in the 2007 2 SCC. That is not considered in this decision, Lordship. This is also consist of 2 judges benches, Lordship. This is specifically stated, Lordship. The other judgment is also considered. I could not see.
My lord, para number, my lord, kindly para number 8, my lord. The Pratap Narayan judgment, my lord, that is 4 judge bench, my lord, judgment. Para number 8, my lord. Page number, my lord, 292. May I read, my lord? It was the duty of the appellant under section 4A1 of the Act to pay the compensation at the rate provided by section 4 as soon as the personal injury was caused to the respondent. My lord, yet here it is clearly stated that as soon as personal injury was caused, that means, my lord, from the date of accident, my lord. It is clearly interpreted, narrated in this judgment, my lord. It is from the date of accident, my lord.
Lordship, may kindly take up this matter as soon as your Lordship can fix it, because I could not go through all this judgment. And today I'm unable to assist also. I could not read.
Okay. Yes, praying for the adjournment because.
Okay, my lord, I have no objection, my lord. Date may be fixed, my lord, this month, my lord.
Yes, yes.
I'm giving the citation number, my lord.
Yes,
The
sir.
to other side, my
I
lord.
will go through the
Will,
judgment.
will
Yes.
keep here in the case record.
Yes, my lord.
Yes. Maybe on 24th of February, Lord. 24th February.
And yeah, settle down, council for the response. MSM children did for an adjournment. Stating that she has some personal inconvenience to the prayer allowed. Estimate 24th February, you are saying?
Yes, Lord. If it is possible, Lord.
Or maybe possible. 24th.
Yes.
My lord, I am.
Yes, yes.
I have. In a date.
24th February will be convenient for you?
It's a Thursday. Thursday, heading to. No.
Okay, my lord.
I'm sorry, Lord.
But he